Everyone's in.
All right, thank you. Good afternoon. We'll call State of Wisconsin versus Robert D. Carver, 20 CF 612 appearances, please.
Yes, I'm here.
Mr. Gravely, I believe you're on mute.
Sorry.
There you go.
Did you unmute me?
Yes, you're
Yeah.
unmuted.
Okay. The state appears by Mike Gravely of the Kenosha District Attorney's Office. Victim Cassandra Harris appears by Zoom as well.
All right, thank you.
Attorney Thomas McClure appears by phone, and defendant Robert Carver, my client, appears by phone.
All right, thank you. Mr. McClure, no objection to this hearing being held via the Zoom application, correct?
No objection.
All right, thank you. All right, as to the criminal complaint then, Mr. McClure?
Judge, I have no comment.
Did you receive a copy of the criminal complaint?
Yes, and my client has as well, and we've reviewed it. We waive a reading.
All right, well, you're going to enter a plea, or do you want the court to enter pleas?
I'm not guilty.
This is a felony, and so we'd be asking for a preliminary hearing.
All right, then request for preliminary hearing. Oh, I see that. Request for preliminary hearing is noted and entered for the record. And as to bond then, Mr. Gravely?
Your Honor, I don't have a specific argument to make about the monetary aspects of bond. I do want the court to be aware that this is a case where I believe that the police did not place the defendant in custody. The district attorney's office made the decision that this was appropriate for criminal charges. And so we appreciate the court being able to accommodate us on the soonest summons date that was possible, which the court provided as today. Obviously, the evidence in this case is strong in the sense that there are multiple witnesses to the conduct, and that the driving conduct is on video and is accessible on video, and so in terms of the proofs in this case, they are strong. And one of the aspects of this case is, of course, dangerous conduct with a vehicle, using it as a weapon. So this is a felony where a weapon is alleged, in the sense that the defendant is alleged to have used his vehicle. And of course, with the hate crimes enhancers attached to both, from the state's perspective, these things should be recognized in bond. It's a shameful complaint to read in terms of the allegations of conduct that occurred here in Kenosha. I'm heartened by the reactions of the other individuals in the parking lot who came to the direct aid of the victim in this case. One of the witnesses in this case, Your Honor, waited in that parking lot for 2 hours to be sure that his what he witnessed was available to law enforcement. So I don't have an argument specifically about the bond, other than I'm asking for conditions of bond that include no contact with Cassandra Harris or her family. I'm asking the defendant be ordered as a condition of bond not to drive a motor vehicle while this is pending. Obviously, he used a motor vehicle as a weapon per the allegations, and so should not be utilizing a vehicle based on the allegation he used one as a weapon. And I'm also asking, Judge, that the defendant engage in no public communications in any kind of public location that would be characterized as racial slurs. I don't believe that, again, that the defendant is an individual who these allegations indicate he used those slurs and words in an aggressive fashion, in a fashion that provoked a dispute. And so I'm asking that the court limit him and not allow him to use racial slurs in public settings and in publicly communicating with others. And I believe, Your Honor, that the victim in this case would like to speak briefly as to the bond as well.
All right, thank you, Mr. Gravely. What about David Herrick or Noah Reeves, are reported witnesses?
Yeah, those are witnesses in the case, Judge, and I'm going to ask that they have no contact with the defendant as well.
All right, thank you. And I know you mentioned no not being on the premises of Menards as well. Is that correct?
They've banned him, I've been told, but certainly I believe that's also appropriate.
All right, thank you. All right, what I'll do, I'll listen to your argument first, Mr. McClure, and then I believe Ms. Harris wishes to address the court, and I'll allow that as well, of course. So, but first, Mr. McClure?
Your Honor, my client has never been accused or charged of a crime in his life. He is 78 years old. He is a longtime resident and homeowner and businessman in the area. I understand from what has been reported about this, there's a lot of emotion and concern, but there's another side to this, believe it or not, and in time that will come out. For the moment, I believe because this was brought in on a summons, because the police did not require any bond, I believe the court can achieve its desire to make sure the defendant appears for bond, because he's obviously not a flight risk or going anywhere. So I would ask for a reasonable personal recognizance bond. I have no problem with a no contact with any alleged victim or alleged witness. That's standard in these things. I do object to the fact that he is to be peremptorily taken out of his driving privilege. I believe that is almost unprecedented. I've never seen that before, and I've been practicing law for 35 years in 10 criminal courts. I've never heard of anyone being told they can't drive until the end of a case on an allegation. So I would object to that. And there was one other condition I can't recall. If you could assist me, Commissioner, that Mr. Gravely talked about that I was also going to object to, but quite frankly, I can't remember what the other one was besides not being allowed to drive a car.
All right, Mr. McClure, I believe that was that the state requested that Mr. Carver engage in no public communications which could be characterized as racial slurs or making outbursts in public that which could be characterized as racial slurs.
Well, for the record, that wasn't going to occur. I've never seen that before, either on a bond, but if the court feels that's important for the public to see something like that, then we'll have to go along with that, I guess. I guess it's some kind of gag order or something in advance, but I would object to it for the record. I am not trying to be insensitive to the alleged victim or to the public in the county. I am merely protecting my client's rights the same way Mr. Gravely is trying to protect his.
Court's aware. All right,
Your Honor, I'd like to briefly be heard on the driving issue if the court wishes me to argue.
I will in a minute, but I think your screen might be frozen at this point, Mr. Gravely. But
okay.
I just wanted to put on the record, Mr. McClure, the court's aware of what your role is and what you're seeking to accomplish. Just so I'm aware of that, sir.
All right.
Yeah, and I have a question though. Does your client? You said he owns a business. Does he operate a motor vehicle in conjunction with a business operation?
He's a part-time remodeler, semi-retired. He had a remodeling construction business for many years.
All right. Mr. Gravely, you wish to add?
Well, I do, Judge. Certainly, to ask as a condition of bond that someone not drive a vehicle is rare. But in this case, we're asserting that the driving of the vehicle is the way that a weapon is utilized. So I believe this is directly analogous to if somebody wielded a knife or a firearm, and that was the weapon alleged, the court would likely order that the defendant not be able to use or possess that weapon during the pendency of this matter. In this case, there is video of the defendant accelerating into a parking space occupied by this victim who has to move out of the way to avoid harm. So this is not going to be able to be disputed. And it is in the context of the argument witnessed by multiple people where racial epithets are being yelled. So Your Honor, this is a case where the vehicle is a weapon. It's being used as a weapon, and just as I would on a firearm or a knife, I'm suggesting the defendant should not have access or use of what he utilized as a weapon while this case is pending.
All right, thank you, Mr. Brady. Ms. Harris, this is the commissioner speaking. Did you wish to address the court?
Yes, I would.
All right, you may go ahead, please.
I just want the court to know that this incident that happened, it happened to me. It is real. It is unacceptable. I don't care how they try to make him like he was an outstanding citizen. He was not that day. I did not deserve to be called out of my name. I did not deserve to be called N-words. I did not deserve to be called F myself, and I'm a lazy N-word, and other nasty slurs. And where he gets so upset, he jumps in his Hummer and tries to run me over, where I had to jump out the way and have my daughter crying in the car because she almost witnessed her mother get ran over that could have ended up in my death. So I understand his attorney has to take up for him, but I am a victim, and I don't appreciate him trying to uphold like he's some outstanding citizen when he could have ended my life for no reason. And all I did was ask him, why did he feel that way? He should not talk to me that way. And I never used any type of slurs at him. And it was just over a cart, a shopping cart, where he felt he can come at me and start disrespecting me and calling me out of my name using racial slurs. And that is not okay. And it is not okay that if you have a disagreement with someone, that you would jump in your vehicle and try to take their life and in front of their child. That is not okay. And I don't have a criminal record either.
All right.
And that's how I would like to address the court. And I thank and appreciate the court for listening to me.
All right. Thank you, Ms. Harris, for addressing the court. All right. Well, the court has reviewed this criminal complaint, understands these are, at this juncture, allegations. Nonetheless, they are violent, they are vile, if you will, and uncalled for and unacceptable. And again, allegations, court's well aware. I can't state that any stronger. I do want to send a strong message to this community about what behaviors, as alleged here, are simply short and sweet, unacceptable, and will not be tolerated by this court. And again, I do recognize at this juncture there are allegations. What I'm going to do here is this came in on the summons and complaint. Mr. Carver was not taken into custody. He has retained counsel, so I do not believe he's a flight risk. Court is going to impose, at this juncture, a $5,000 signature bond. Mr. Carver, conditions of bond are as follows. You are not to be present or be on the premises of the Menards store in Kenosha County. You may not have any contact with the following individuals: Cassandra Harris, David Herrick, Noah Reeves. So we're clear, no contact means no contact in person, no third-party contact, no contact at their residences, their places of employment or school, any place they temporarily occupy, including but not limited to a house of worship, a store, a restaurant. No electronic communications with any of them, no phoning, texting, or social media contact, no writing of any type, including handwritten notes, letters, and cards. In addition, sir, I'm going to require that your only driving that you're going to be allowed to do would be in an emergency situation in which you have to seek medical care or treatment, or if you need to pick up medications for, if you are on medications, or a grocery store just to get the necessities of life. That's the only driving you're going to be doing under bond, sir. You're not going to operate a vehicle for any other reason, including employment. You are to appear in court every time when required and not commit further crimes while you're out on bond. Do you understand all of those conditions, sir?
Yes, I do.
Thank you very much.
Preliminary hearing, July 7th at 9:45.
Madam Clerk, I'm gone that week of July 7th.
Okay,
I'm back the week after that.
I would have to go into the week before to be within time limits.
That's also fine.
July 2nd at 8:30.
July 2nd at 8:30 is fine with the state.
I have a pre-trial in another county, Milwaukee, at 8:30. Do you have anything on Friday, July 3rd?
There's no court that day.
All right. Do you have anything mid-morning? Like
I have
10 o'clock?
9:45 or 10:15.
Let's do 10:15.
That's fine with me as well.
Okay, so July 2nd at 10:15.
One other thing, I'm sorry, I wanted to add here, Mr. Carver, as a condition, I'm going to order that you not engage in a public forum or in public the use of racial epithets or slurs. Do you understand that as well, sir?
Yes, I do.
All right, thank you.
Your Honor, I have one question.
Yes.
I'm asking that no contact with anybody who is in Cassandra Harris's family, and obviously that would be intentional contact. But I don't want the defendant. I want him to be prohibited on bond to contact anybody he knows to be a family member of Ms. Harris as well.
All right, Mr. McClure.
Judge, my client has had no contact with anyone and has no intention of contact with anyone. He's not familiar with Ms. Harris or anyone else involved in this matter.
All right, then it should be easy. Then I'll order it. Mr. Carver, you may not have any contact with anyone in Ms. Harris's family, and that's intentional contact with anyone in Ms. Harris's family or anyone that you wish to use as a third party to send any message to Ms. Harris or her family as well. Do you understand that as well, Mr. Carver?
Yes.
All right, thank you.
That'll conclude the hearing.
Thank you, Your Honor.
All right.